list number 1, serial number 20. List number 1, serial number 20. Ronald.
The probate CP is filed
Your Lordship wishes to have any further clarification?
No. in this petition. The learned counsel appearing for the petitioner had made certain submissions, and now on those submissions, the matter is placed before this court. Learned counsel appearing for the Succession Act, Court Fee Act rules. Learned counsel appearing for the petitioner submits that with regard to objection number 3, that is the concurrent jurisdiction to be stated, it is submitted that to the present case, section 300, the Succession Act is not applicable, and it is section 273 alone is applicable, and the properties in respect of this petition are situated not only in the state of Karnataka but also other states. In view of the same, the concurrent jurisdiction as specified as per section 300 need not be stated, as section 273 is applicable. This court had heard the learned counsel with regard to the objection number 3, and the office objection with regard to the same is overruled. When coming to the witness affidavit not forthcoming, it is submitted that the certificate has been filed in compliance with Rule 5A, one of the rules governing probate and administration matters 1964, read with form number 2 prescribed thereunder. Their affidavits, the said rule doesn't prescribe about filing of the affidavits. Learned counsel has drawn the attention of the court to Rule 5A1 and form number 2 of the rules, and this court has perused the same, and as rightly pointed out by the it is also submitted that during the course of hearing, if the court deems it appropriate that an affidavit is filed, the affidavit is required and to be filed, then the petitioner will come up with the affidavit. Looking at the Rule 5A of the rules and form number 2, and the submission of the learned counsel for the petitioner that, if required, they'll during the course of hearing, they'll come up with such an affidavit if necessary. On that condition, the objection with regard to the witness affidavit is also overruled. Then the fifth objection is with regard to the filing of an IA for dispensation of notice to Deputy Commissioner is not forthcoming. In this case, Land Council has drawn the attention to the Court Fees Act, has drawn the attention to Section 52 of the Court Fees Act and submits that as per Section 52, on application for probate for letters of administration, the court has to send the copy with the valuation to the Deputy Commissioner of the district in which the estate is situated, or if the estate is situated in more than district, the Deputy Commissioner of the district in which the most valuable portion of the immovable property is included, to send the valuation report. He submits that the whole purport of Section 52 and sending the same to the Deputy Commissioner is for the purpose of, to see that the court fee is not evaded and for determination of the correct court fees. Then he had drawn the attention of the court to Article 6 in Schedule 1, where the amended, which was amended and came into effect from 27/4/2000, as per the same, as per 6A, when the amount of the value of the property in respect of which the grant of probate or letter is made exceeds 1,000 rupees, or value in excess of 1,000 rupees up to 3 lakhs of rupees, 3% is the court fees. And when the amount or value of the probate in respect of which the grant of probate or letter is made exceeding 3 lakh of rupees, exceed 3 lakh of rupees on the part of the amount or value in excess of 3 lakh of rupees, 5% or rupees 30,000, whichever is less. He submits that in view of the same, as the amount, the value is above 3 lakhs. They have already, the court fee is mentioned as 30,000. In that case, the question of sending it to the Deputy Commissioner for valuation is not required in the light of the amended Article 6 of Schedule 1. This court had considered the Section 52 as well, Article 6 of Schedule 1, and as it shows that the maximum fees above 3 lakhs is 5% or rupees 30,000, whichever is less. In that view of the matter, no purpose would be served in sending in calling for a valuation report from the Deputy Commissioner in view of the same. IA for dispensation of notice, the objection number 5 is also overruled. Then objection number 6 says description of respondent not forthcoming and why you made party to this petition. The council had relied on the judgment of the Apex Court in Swaminathan versus Alankamani 2020, reported in 2022, Live Law SC 276, stating that the reason for impleading the respondent has been explained in para 4 of the petition, that she is in addition to the petitioner is the only other intestate heirs of the deceased, that all the intestate heirs have to be given an opportunity to participate in the proceedings laid down by the Apex Court. as per the apex code. In view of the same, the said objection is also overruled. Yes. This is matter for admission.
May I make a submission? Just as a benefit to the litigants and counsel, such objections need not be raised henceforth in other cases, because I've got similar objections which have been raised. Because they feel a little
No,
reluctant.
they say that there is some order. What is that you are showing? Some
That order also was not
some
quite,
judicial order was passed.
that's not quite right, my lords.
Let's see that. What is that?
I'm aware of that also. In view of that, they have started becoming a bit panicky for
We'll just see.
not to be.
Just taken that. I'll look into that and then pass that order. Yes,
It may be posted for
admission.
admissions.
Yes. Call.
Pass over in list number 1, serial number 17.
Where is the judgment?
Please, ma'am.
Take that.
Samira Rani.
Paragraph number.
Para 9, my lord. Relevant para. All of them, they are residing separately, madam. In this case, they are residing with her. So they are not proved that they are residing with her and entirely dependent.
No, in this case, the
Yes.
court says
Yes, ma'am.
she is residing separately and earning 1,50,000.
Yes.
That is also recorded. One, the court records that,
Yes.
that 1,50,000 is not sufficient
Yeah.
and grants it.
Largely the dependent earnings of the deceased and they were staying with her. That is the,
That's not the criteria. It is about 1,50,000.
and
So in that case, we have to, because they already adduced evidence saying that they are dependent. You have not cross-examined, you have not elicited anything.
they are stated in a straight sentence, one sentence, we are depending on that. It cannot be believed.
No, the cross-examination, that's a burden,
Cross-examination, we are not done effectively. There is no, that is there.
as it generally happens.
Yes. And I would like to bring to your lordship
Hmm.
notice other two decisions.
Take that.
My lord, New India Assurance Company versus Vinesh Jain. Para
2018. Yes,
Para 7, my lord.
yes.
Third line, the major sons have their own source of income were not dependent on the deceased.
That's all, that all depends upon facts of each case. Then what about the other one?
Yes, she herself says they are earning, they are working.
No, in this case, Shima Rani's case,
Yeah.
court says they're earning.
Yes,
That earning is not sufficient, so we have to treat them as dependents.
yes, ma'am.
Then what about this?
Another division bench, paragraph 14, my lord, your lordship. That is all, wherein it is stated, the claimants are living with her and not in dispute. Therefore, the tribunal is right in considering 25% of her income towards the loss of estate. In this case, they are residing there, so 25%.
No, this is what the division bench said. Now we are bound by what the Supreme Court said.
Yes,
So how the Supreme Court concerned normal pattern, like how it is future prospects, deduction, multiplier, everything is same. So what is the age in this?
49 years.
not
Huh?
49, my lord.
Claim 20 lakhs, that's the case. Taylor, 88,000 is her income, that's according to them.
Please, ma'am. And pension.
Pension is 6,972. She was getting family pension.
So put together,
Term.
8 plus 6, 14.
Yes.
14,972.
Well, she was aged, even according to them, Exhibit P17, one of the age
49
of the
years.
sons is 47 years. And PW1 says my brothers and my mother's age difference is 20 years. So that comes to 65 years.
How can she be 49 years when the son itself is for 45 years?
On that regard, my lord, cross-examination was done.
No, exhibit, they are given the exhibit, their own exhibit says.
No.
On that
Please
point,
come how you arrayed yourself in the cause title.
please.
Let's see in the MBC,
This is MBC
Nagaraju,
1108 of 18.
38 years, 35 years, 23 years. And according to you, the mother's age is 48.
49. 49. She
This
claims,
she is 11 years older to him.
please. That is the claim. I must concede, my lord. In the evidence also, cross-examination, on that point, there was effective
They say
cross-examination.
that she is 20 years elder to them.
That was the cross-examination suggestion.
So in that case, 38 years, 20 means 58 years.
No. One of the son's age is 45 years. She says,
No, nobody is 45 years old here.
Exhibit P17, madam. Your lordship may kindly take up Exhibit P17. The
No.
Aadhaar card given, that is one of the son's age is 45 years, that is Devaraj.
I think there are two MBCs. Which
It-
MBC is
This relates to 1108 of 18.
1108. Please look at, come to page 7. Cost title.
A cost letter, your lordship, then they dot mark the Aadhaar card. Exhibit P17 in the record. ma'am.
Give that.
Look.
Whose Aadhaar card is this?
That is Devaraj, my lord, the date of birth in 1971.
1971. And date of accident is?
Is 18, my lord, 2/2/18. That comes to 47 years.
40?
47, but
Yes, we'll take her age at 67.
Please.
Hmm? 67 will take. So her salary is, her income is,
14,000.
which year is the accident?
2018.
2018, man.
12,500 has to be. 12,500.
12,500.
12,500.
So 12,500 plus what is she getting? 6,972. It come to 28,472. How much has to be 1/4? How many are the claimants?
Three.
There are
4.
five,
1/4.
four sons and,
1/4 has to be deducted.
yes. 3 ಜನ ಅಲ್ಲ 4 ಜನ ಗಂಡು ಮಕ್ಕಳು ಒಬ್ಳು ಡಾಟರ್.
No, as per the Malad claim petition, Malad, there are 3 claimants. There are 3 claimants.
R1 is the
That
son.
is not proved, Malad. That is
What
not-
proved? You can see the name, you can see you referred as the son
No.
of so and so.
Whether it is forthcoming from the judgment?
Yes, my lord, even in the
No,
cost.
not from the array of cause title. Is it forthcoming? Is it anybody's case? Is the respondent is a son? That's what we were discussing in the prior to lunch.
Yes.
So there is nothing is there we can't. So how many are there?
3
Like,
claimants.
you know,
Three
One
dependents.
third has to be deducted.
Please, Malad.
my lord, she has clearly stated who are the brothers.
Who said?
That is PW1.
Where do you get that?
That in the deposition, my lord. in the cross
Oh, the claim
examination.
petition. No, it is like this. Claim petition by so and so people.
Yes,
They will get the compensation.
they get
How
it.
will we, do the exercise in respect of parties who are not claiming compensation?
But they are the legal heirs.
Where is the discussion in the judgment on that?
There is no discussion because
We'll
those
just leave it
contentions will
there.
not rise before the tribunal.
472. What is the multiplier?
The multiplier is 5.
It comes to 13 lakhs 16,860. Please come.
I'm submitting. Yeah. But, though it is persuasive in nature, other
Huh?
high courts may not consistently following the behavior things in order to dependency cases concerned.
Huh?
Dependency aspect is concerned. Other courts are following the behavior things and considering the major and married daughters as a dependent and awarding.
Granted.
Please,
What else you want?
please.
Supreme Court judgment. Agreed with the orders passed in MBC number 1108 of 2018 dated 22nd August 2019. The claimant is before this court. The claimants are the wife,
No.
sorry. The claimants are
Daughters and son and
son, two sons, and two major sons, aged, two major sons, and daughter. It is a case of the claimant that she is doing tailoring work and earning an amount of rupees 8,000 per month and also receiving pension of an amount of rupees 6,972. The court on the issue of liability and the rash and negligence has held that accident has happened because of the rash and negligent driving of the driver of the offending vehicle, and as the same is insured with the insurance company, they're liable to pay the compensation. When it comes to the compensation, the court has observed that the claimants are married sons and daughter of the deceased and are independently living with their lives, and they were not dependent on deceased, and therefore they are not entitled for compensation under the head of loss of dependency, and accordingly granted an amount of rupees 15,000 towards loss of estate, 15,000 towards loss of funeral expenses. Altogether, a compensation of an amount of rupees 30,000 is granted. Learned counsel appearing for the claimant submits that even the major married sons and daughter are entitled for compensation. In this regard, he had relied on the judgment of the apex court in Birendra Singh's case and also the latest judgment in Seema Rani's case. That is in Seema Rani, reported in 2025, neutral citation 2025 INSC 192, in case of Seema Rani and others versus Orient Insurance Company Limited and others. He relied on paragraph number 9, 10, extract. Relying on this judgment, he submits that it is a case that they are dependent upon the deceased, and the insurance company could not elicit anything in the cross-examination that they are not dependent upon the deceased. In view of the same, they are entitled for the loss of estate. Next para. Land counsel appearing for the insurance company submits that the major daughters, the major married daughter and son who are living independently are not entitled for compensation and are not entitled for the under the head of loss of estate. He had relied on the judgment of the apex court in New India Assurance Company Limited versus Vinish Jain and others, reported in Law SC 2018-264. He relied on para number 7, extract. And he has also relied on the division bench judgment of this court in MFA number 7070 of 2014, arising out of in the case of Baby and others versus Nagendra Kumar and others, dated 13th June 2023. He relied on para number 14. Relying on these judgments, when counsel submits that the major married daughter and son who are living separately are not entitled for any compensation. It is submitted that the court had rightly granted the loss of estate and funeral expenses. Next para. Having got the learned counsel for the learned counsels on either side, there is the material on record. The present appeal is only seeking enhancement. The issue that is involved in this case is with regard to the issue that is involved is whether the major married daughter and son who are not living with the deceased mother are entitled for compensation. The learned counsel for the insurance company had relied on the judgments to say that they are not entitled for the compensation, and according to him, in Seema Ramni's case, they are living with the deceased, whereas in this case, the petitioner, the appellants are not residing with the deceased and they are not dependent on them. This court has perused the judgment that are relied on by both the parties. In the latest judgment of the apex court in Seema Rani's case, the apex court had considered the earlier judgment of the apex court in National Insurance Company Limited versus Birender and others, reported in 2011 SEC 356. And coming to the facts of the said case, the court has even observed that in Birendra's case, in that case, they were earning merely rupees 1,50,000 per annum, and as they were legally dependent on the earnings of the deceased, court had passed an order. And in the facts of the case, in Seema Rani's case, the apex court has observed that they were working, the claimant were working at a petrol bunk while the other son was involved in temporary employment opportunity. Both of them are residing with the deceased. In such circumstances, it cannot be said that they were self-sufficient or independent of the deceased, or not dependent on the deceased. Hence, the court had granted the loss of dependency, also the loss of dependency. Applying the ratio laid down in the said case to the facts and circumstances of this case, in this case, there is a clear pleading with regard to the dependency, and nothing could be elicited by the insurance company to show that they are not dependent. When it comes to the age, though it is stated that she is 49 years old, in the evidence, learned counsel appearing for the insurance company submits that in the evidence it is forthcoming that the son is 47 years old and the mother is 20 years elder to him. In that case, her age has to be considered as 67, but not 49, as stated by them. The accident has taken place in the year 2018. Considering the chart. No, when you yourself have said that your income is 8,000.
Income, my lord, pension 6,970 rupees,
Ah.
8,000 rupees by tailoring.
So then why should we take 12,500 as per 2018 when it is your own case?
It's not proved income.
Huh?
It is not. I have not produced any document. Therefore,
No.
usually,
No, not that.
please,
You were claiming that your income is 8,000.
please.
Even whether you have proved or not, if the income on that particular year is more, we can we can take it. If it is less, we can take 8,000. But you are saying that it is 8,000. Why should the court take 12,500?
It should be restricted to 8,000.
It should be restricted to 8,000.
Since beneficial legislation,
Huh?
beneficial legislation.
Beneficial legislation doesn't mean that court will do something which is beyond the pleadings of the parties, sir. That's your case, sir. $8,000 plus 6,000.
972.
972. It comes to 14,972. $9,981 into 12 into, you said 5.
5.
$5,98,860. It comes to 7,76,860. What did you write? Huh? According to the claimant, which is earning an amount of rupees. According to the claimant, the deceased was earning 8,000 by doing tailoring and 6,972. And she's getting a pension. Considering the accident is of the year 2008 and as per the pleadings, if the same are taken, it comes to 14,972. There are 3 dependents. One third has to be deducted towards the 1/3 has to be deducted, and the same is deducted would come to 4,990. The contribution of the deceased to the family would be 9,981 into 12, considering the age of 67, multiplier 5, loss of dependency would come to 5,98,860. Towards consortium for the 3 dependents, 3 into 44, 1,32,000. Funeral expenses 36,000. Legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 7,76,860. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 30,000 to 7,76,860. The enhanced amount shall carry 6% interest.
Play, this has been.
It is already passed.
Yes, ma'am.
Let us see.
5/4
Where is that?
2024, my lord, order.
Proceeding sheet. Take this. The delay on 5/4/2024, delay is condoned on the condition that they will not be entitled for the delayed period of 391. It will not be entitled for interest for the delayed period of 391 days. As such, the claimant is not entitled for 390 interest for the period of 391 days. Yes. Yes, next.
For admission, serial number 21, list one, sir, 21,
Let's
Shreya Prasad Shantanu order.
plaintiff's second appeal.
Yes.
Suit for bare injunction, my lords, filed in the year 2016 January. My lord, the defendant has been served in the month of April 2016. He does not file his written statement for a period of 1.5 years. Then he files an application for recall, seeking permission to file his written statement. That is allowed subject to a cost of rupees 500, and he also files a counterclaim. But he does not pay that cost of rupees 500. So that is not been considered. He does not even cross-examine the witness from the year 2017 to 2020. The suit is decreed, my lords, in the year 2021.
Suit is of the year
2016, my lords. He served on this in the same year, April 2016 he served. The matter is set for cross-examination in the month of 10/8/2017. He does not cross-examine the witness. Then on 14/9/2017, he files an application for recall, seeks permission to file his written statement and counterclaim. That comes to be allowed, my lord, subject to a payment of rupees 500 cost. That he does not pay. Therefore, the court does not consider his pleadings. But he does not come and cross-examine the witness also. Thereafter, my lord, the suit came to be decreed on 6/11/2021. Now, my lords,
On merits.
on merits, my lords, considering all the documentary evidence which I have produced. My lords, he files 2 appeals, one with respect to decree in my favor and the counterclaim. My lords, his ground for not participating in the suit is at page number 24, my lords, which has been called out in the appeal memo, in the judgment of the appellate court. Page number 24, my lords.
Page number?
24, my lords. 24. C, my lords, paragraph number C. Due to the onset of the pandemic, he was under the impression that no adverse order would be passed in view of the standard operating procedure that was in force. He had effected COVID-19 repeatedly on 3 occasions. His non-appearance was on account of the aforesaid bona fide reasons, which was beyond his control. However, the trial court has failed to consider the aforesaid crucial facts. From the year 2006.
What is the suit for?
Bare injunction, my lords. Suit is for bare injunction.
What is the counterclaim he sought?
He also seeks for injunction. But he does not participate in the proceedings. He does not even cross-examine me.
Please come to the order.
My lords, the appellate court's order, reasoning, my lords, is at page number 37.
Page number?
37, my lords, 37. Paragraph number 25, my lords. That apart, the Honorable Trial Court on 4/9/2021, by relying on the earlier order dated 5/3/2020, passed an order that the cross of PW1 and defense evidence is taken as nil. No doubt the written statement of the defendant is not taken on record and he has no right of defense evidence. But that does not mean that he has no right to cross-examine PW1. In this regard, it may not be wrong to rely on the ratio laid down by the Honorable Apex Court in judgment so and so with connected appeals, wherein the Honorable Apex Court has held that at this stage we must clarify the legal position. Even if a defendant does not file a written statement and the suit is ordered to proceed ex parte against him, the limited defense available to the defendant is not foreclosed. A defendant can always cross-examine the witnesses examined by the plaintiff to prove the falsity of the plaintiff's case. Therefore, it is clear that even if the defendant has not filed written statement, his right of cross-examination by PW1 plaintiff cannot be curtailed, and he has an opportunity to show that the case of the plaintiff is false. The Honorable Trial Court ought to have provided another opportunity to the defendant. Hence, with due respect, it may be opined that the procedure adopted by the trial court may not be proper in the eyes of law, and this case needs to be remanded for fresh trial. For a period of 4 years, he has been given an opportunity to cross-examine. He does not. The trial court, the appellate court says that one more opportunity needs to be given to him.
Come to the order of the trial court.
Trial court order, my lords, is at page number 49. Paragraph number 10, my lords, 10 and 11.
No. Read para 5.
Of the trial court order. In order to prove the plaintiff's case, the plaintiff examined himself as PW1 and got marked 19 documents as per exhibit P1 to P19. As above stated, on the other hand, even though the defendant appeared before the court through his counsel and filed counterclaim, but as per the order dated 5/3/2020, the defendant was placed in the same position as if he had not defended and not filed any counterclaim, and the matter was posted for plaintiff evidence. After that, the plaintiff has led evidence, but the defendant has not represented himself before the court and failed to cross-examine PW1. As such, the cross of PW1 and defendant evidence was taken as nil, and the matter was posted for arguments.
He has not contested.
He has not contested. He only files written statement that was allowed subject to a payment of ₹500 cost. He does not even pay that. He does not even cross-examine me. He does not even lead evidence for a period of 4 years, my lord, from 2016 to 2020. Now the appellate.
Oh, what is the interim order you want?
My lord, now the matter is again remanded back to the trial court. I have to again face the trial after a period of from 2016 to 2021 for a period of 5 years.
Please come. The present appeal is filed. Agreed with the order passed in RA number 57 or 6?
57, my lords.
57 of 2022, dated 19th December 2024, whereby the appellate court had set aside the judgment and decree passed by the trial court and remanded the matter to the trial court for fresh consideration. Land counsel appearing for the appellant plaintiff submits that the suit is of the year
16, my lords.
2016, and after the notices were served, the respondent, though appeared in 2017.
2016 itself, he has.
16, he has not filed the written statement. Then what has happened on 10/8/2017?
Matter was posted for cross-examination.
The
of
matter
PW1.
was posted for cross-examination at that point of time. An application is filed on 14/9/2017 to recall the earlier order, and the order was recalled on the condition that he should pay costs of ₹500.
Please.
That costs were not paid, and thereafter he filed a claim petition, counter claim, and even that was not contested. Thereafter, the court had thereafter the court
6/11/2021 it was decreed.
and after that an order was passed on 5/3/2020. The defendant was placed in the same position as if he had not defended and not filed any counterclaim, and the matter was posted for plaintiff's evidence. After that, the plaintiff has led evidence, but the defendant has not represented himself before the court and failed to cross-examine PW1. And the evidence of PW1, the cross of PW1 and the defendant evidence was taken as nil. And the matter was posted for arguments. Thereafter, the suit came to be decreed. It is submitted that now when an appeal is filed with the claimant, with the appellate court without even considering the fact that throughout the case, right from 2016 till the judgment and decree is passed, the appellant, the respondent, defendant has not contested the matter. And without any basis, now the judgment, now the court had set aside the judgment and decree and remanded the matter. Next, having heard the argument of the land counsel, this court has perused the material on record. The reasoning that is given by the appellate court that an opportunity should have been given by the trial court, and no discussion why the defendant was not prosecuting the matter right from 17 to 2020 is the decree.
2021, my lords.
Till 2021. In that view of the matter, there shall be stay of all further proceedings in OS number
151 of 2016.
151 of 2016 on the file of the third additional civil judge, Bangalore. Till the next date of hearing, learned counsel for the petitioner shall take out hand summons on the counsel appearing before the trial court for the respondents and file a memo to that effect by 16th of April. If the memo is filed on 16th, list this matter on 21st, or else the stay granted by this court stands vacated.
Much obliged. That's Bangalore rural district.
Bangalore rural.
Much obliged.
List number 2. Order sale number 1, Marigowda for appellant B. Pradeep.
He was here just now. He's not the one.
Yes, ma'am. Yeah, madam,
Awaiting
the
medical
report has-
examination report from Minto-alia Hospital.
Eye hospital.
What is
It has
this?
been referred, my lord. Yes.
With regard to
That,
disability?
He has lost vision, left vision.
Uh,
In right vision, he has some problem. Afterwards, he is saying that the right vision also is not, he could not able to see anything.
hmm,
That's why, madam, this honorable court has referred,
Where is the report?
report is still awaited, as per the.
Oh, awaited. List after the report is received from the hospital. Yes, next. Huh? It is on, order is in 14/11/2017. Order, let's see.
2022, my lord.
Appellant Sri Marigod has presented and submitted that the petitioner has attended the medical examination, Minto High Hospital, but no report is received. Office is office to on 14/12/2022 an order is passed that the registry shall place the report of the hospital. After that, there is no office note also on this. Except awaiting medical examination report. What are the efforts made by the registry is not forthcoming. Registrar Judicial is directed to look into this and place a report before the court. List on first. Yes, next.
Serial number 2, Pradeep D for appellant.
What is this translated copies?
Translated
Copy for respondent.
Statement Kannada.
as per exhibit R1, the IO who has been examined before the court, we have submitted that.
You are
my lord,
questioning the liability.
please, involvement of the vehicle.
Hmm.
Sir, my lord, the first one, son of
What is
the
exhibit R1?
final report.
R1 is the final report.
One,
Hmm.
it has been produced by the
Hmm.
investigating officer. RW1 evidence may kindly be seen.
Hmm.
RW2.
My lord, appear for,
Copy.
my lord, appear for respondent number 1, my lord. Kindly have it on Monday, my lord. Masina is not here, my lord.
We'll see what it is.
Yes.
The complaint given by son of the accused was stated that one Pulsar vehicle is which is involved in the alleged accident, and he was given a complaint before the police after lapse of 25 days. The police officers and the investigating officer who has investigated the matter, it is a false case has been given, false complaint has been given. That vehicle is not met with an accident.
This is a police
Pulsar.
report.
Please.
That's the final report of the police.
Yes, madam. Regarding that, madam, you have summoned the IO has clarified that.
Then what's the finding of the court on that?
Finding of the court is that, my lord, investigation conducted by some other person who is examined before the court is also an investigative officer, but he has not conducted the investigation.
But the final report is,
Yes, report, yes, my lord.
that is recorded.
Yes, my lord.
Come to that.
Para 12.
Please read.
Start from para 11.
Hmm.
The cross examination, he has stated that he was standing near the tea stall. At the time of accident, he has told that police that he has seen the accident. Police have not taken the written statement in the spot, and they have also not written down his statement. However, he has specifically stated that the petitioner's son was not present at the time of the accident, and however, his petitioner's son came to the hospital. He has also deposed that he did not notice whether the rider of a Pulsar motorcycle was presented near the accident spot. Rider was aged about 40 to 45 years. He has voluntarily deposed that many people gathered near the accident place. He has denied the suggestion that the motorcycle is falsely indicated and there is no rash and negligent act on the part of the rider of the motorcycle. To prove the defense, respondent number 2 got examined PSA, traffic investigation wing, Vasu, and RW1 who has deposed that response to the summons, he has produced the true copies of the final report and accident information reports respectively, exhibit R1 to R2. As per the exhibit R1
Yes.
investigation,
Heard the counsel for the appellant at the request of the counsel the respondent. List this matter as part heard on Tuesday.
Much obliged.
25. Cell number 3. Cell number 3, Siteshwara NK for appellant.
That I appear for appellant.
Okay.
That I appear for the second respondent.
This
in
is the
first
malad-
appeal and the seventh respondent.
Claimant appeal. Malad,
And the other is?
other is also, malad, it is in respect of the automobile company. The liability is fixed against the owner and also, malad, automobile of the company.
So that automobile company had filed the next appeal.
Next appeal. First appeal is my claimant appeal. Liability is fixed against owner and this automobile company.
Ground?
Malad, the solely on the ground that, malad, as on the date of accident, the vehicle was not not registered.
Registered.
Not registered. That is the reason, malad. The claimants are the rider and pillion rider. Malad, both are died in the accident. The rider, malad, he filed a claim petition before the Channagiri MESCT, and these claimants, malad, filed a claim petition before Hodalkere MESCT. Malad, Channagiri MESCT, malad, dismissed the claim petition. Against that, malad, the claimants preferred an appeal before this honorable court, which is pending consideration in appeal MFA number 5037 of 2017. But the Hodalkere MESCT, malad, fixed the liability against the owner and automobile company of the.
No, what? It has completely dismissed the case.
Yes, in the Channagiri MESCT, it is completely dismissed. Against that, malad, appeal.
That number?
Malad, it is there in the it was kept below. It is pending consideration before the division bench.
MFA.
MFA 5037 of 2017. Malad, two accidents, but there are two claim petitions.
So
for
we will
claim.
decide this.
Malad, unfortunately, malad, because malad, owner, malad, is dead. Owner is dead. Malad, unfortunately, malad, my counterpart, who, malad, advocate referred me, malad, he died in a COVID. Malad, his colleague, malad, is not responding properly. That is the reason, malad, I am unable to, malad, bring the LRs of, malad, deceased first respondent. But in the connected matter, the deceased first respondent, she is the sixth respondent, represented through a counsel, malad, Shashidhar. Several times we have requested him to furnish at least LR details of the LRs.
He is not here now.
Now he is not here because she is dead. That is the reason.
Father is dead. That's
He told.
Then what to do now?
Now, my lord, at least
5037 ಅಲ್ಲಿ ಏನಾದ್ರು ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಯಾರ ನೋಡೋಣ. ಅದರಲ್ಲಿ ಏನಾದ್ರು ಇಂಪ್ಲೀಟ್ ಮಾಡಿದ್ರೆ
ಅದರಲ್ಲಿ ಇಲ್ಲಿ file it
Connected
is there in
matter also I am
connected matters whether the applications were filed.
what has happened to the notice which is issued in that.
Submitted that the, who is no more?
The owner,
The
first
owner
responder.
of the
So the
tractor
vehicle
and
is,
trailer.
No more, and the LRs need to be brought on.
3 weeks, my lord, I will,
This is matter after 3 weeks.
please.
Yes, next.
Sale number 4,
I appear for the appellant.
Kalyana for appellant.
Have you paid the cost of rupees 1,000?
My colleague is,
Huh?
my colleague ಹೋಗಿದ್ದಾರೆ, colleagues went for paying,
Colleague went to pay now.
afternoon, at
When is
morning.
the order?
It's 20, last
Look at it, when is the order passed?
18/4/24.
Huh?
18/4/24.
18/4?
24.
Oh, that's why you wanted an adjournment in the morning,
Not for this one.
in
I
some
mean,
other matter.
No. It's inconvenience to the senior.
Let's
Not
see.
prepared.
Let us see.
Kindly have it on Monday and I'll prepare and I'll. Monday, please.
Don't worry. Yes, Mr. Samson.
Well, at the case of injuries, the appeal filed by the insurance company challenging the quantum. The
If
accident.
they are seeking enhancement, you are on the quantum.
Yes.
What is the amount claimed?
Well, the amount claimed is 15 lakhs.
15 lakhs.
Amount awarded is 9,58,260.
One minute. Awarded is
9,58,260.
216.
The accident has occurred on 22/2/2014. The injured was aged around 28 years, and he was working as a site engineer, drawing a salary of rupees 22,000.
Court had taken
Court had taken 21,800.
21,800. Anybody was examined in support of the salary?
PW3 is examined.
So what is your submission on this?
Well, what has happened is he has left the services where he was working at the time of accident. Whether he has joined other services, we do not know that. But the court considers 21,800 as income and holds that there is a disability to an extent of 16% and grants compensation. That is the only head on which the appeal is filed.
Then what is the full, what is the disability to the limb?
16%.
46%.
46% to the limb.
And 23%.
It comes to 15.33. The tribunal has
16 taken as
16%.
According to you, the salary shouldn't have been taken as 22,000. Why?
Yes. No, my lord, he might have continued his services as a site engineer or otherwise any other organization. And he has not been terminated from the services where he was working on a medical ground. He did not appear for the employment, and subsequently he has been submitted the resignation. It is not his case that he is not.
What is his occupation, you said?
Site engineer.
Site engineer. And what are the injuries to?
Fracture of left femur, fracture of left tibia. That the disability, what has been considered by the trial court, I'm not against it.
No, I am looking at what would be the impact of that disability on his work. Because he's a site engineer, he had to walk around and do the physically, he has to be.
There is no evidence placed by the petitioner or the injured before the court that his income is reduced after the injury is what he has.
In each case, where is it
Well,
possible?
the only
Mr. Sampath?
the compensation what has been granted.
Please come to the table. Where is? Pain and suffering, good amount is granted.
80,000 is granted. I am not against that. The only point that is being urged is the loss of future running capacity. Medical expenses 1,06,664. Loss of future running 7,11,552. Loss of amenities.
Medical expenses also you are not disputing.
No, I am not disputing. I am disputing only the head number 3, my lord, in the table.
Loss of amenities also reasonable amount is granted.
Yes. And medical expenses are actual.
How many days he was in hospital?
He was
10 days.
in hospital for
10 days. 10 days.
10 days.
Yes.
Which year is this accident?
2014, my lord.
Future medical expenses also you are not disputing.
No, madam. Pain and suffering, it is high by around 20,000 rupees.
What are the, how many fractures?
2 fractures.
We'll have it.
2014, my lord.
60, we'll take it 60.
3 fractures and 2
Huh?
fractures and
Uh,
2 fractures and another on the
that's why 60.
lacerated wound over the slap
That's what,
right side.
2014, that's why the 60. Loss of future earning, his income is
21,800.
21,800.
Trial court taken.
Let the tribunal holds. I have not produced any rebuttal evidence, and that is the reason why I consider income at 21,800. What evidence?
Then where is that loss of earning during later period?
That has not been granted.
That will grant. Taking 21,800 as income into 3 months.
$65,400.
The multiplier.
17 minutes.
Comes to 10,13,616. Yes, come.
Submission. In pain and suffering and loss of amenity and nourishment and convenience fees. That's
You are there in hospital,
for 10 days, madam.
16,000 is granted.
For
1,000 like that we are calculating. 16,000 is granted.
somebody.
Future medical expenses 20,000. Amenities 30,000. That is also proper. And the
future
loss of
medical
income during
expense.
the later period is not granted. That I have added now.
Pain and suffering is have 3 fractures, madam. Is went surgeries and all. That's
Two fractures you said. 2 is it 3?
3, madam.
2 fractures.
Madam, my lord. Fracture on left
Doctor
femur
evidence
lower.
itself, fracture of
Left
lower end
femur.
of femur, fracture of tibia. That is what the doctor said. Evidence. I have the copy of the doctor.
2. Please.
Another one, my lord.
Huh?
Lacerated wound over slab.
Lacerated wound is not fracture.
Oh, it's,
Agreed with orders passed in MBC number 1062 of 2024, dated 18 March 2015. The insurance company as well as the claimant are before this court. Insurance company's appeal is MFA number 4077 of 2015, and the claimant insurance company's appeal is MFA number 4795 of 2015, and the claimant's appeal is MFA number 4077 of 2015. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs for the injuries sustained by the claimant in the accident. It is a case of the claimant that because of the injuries sustained in the accident, as per the evidence of the doctor, he has sustained 46% disability to the limb and 16% disability to the whole body. He is working as a site engineer and he is earning an amount of rupees 22,000 per month, and he was aged 28 years. He had sustained 2 fractures, and considering the salary at 21,800 and the disability at 16%, the court had granted the compensation as per the following heads. Next one. Learned counsel appearing for the insurance company submits that there is no evidence on record to show that because of the injuries sustained by the claimant, it had an impact on his future earning. Without there being an evidence, the court cannot grant the loss of future earning. It is submitted that the court had, in fact, gives an observation that the burden lies on the insurance company, but it is submitted that, in fact, the burden lies on the claimant to prove the same when he's seeking compensation under the head of loss of income, loss of future income. It is submitted that even under the head of pain and suffering, the amount that is granted by the tribunal is on the higher side. Next paragraph. Learned counsel appearing for the appellant claimant submits that considering the disability of 16% to the whole body, the compensation that is granted by the tribunal is on the lower side. He submits that no compensation is granted under the head of loss of income during the later period, and under the other heads, the compensation that is granted is also not reasonable. As such, the compensation needs to be enhanced. Next para. In the same para, he submits that the court had rightly held that the burden lies on the insurance company to prove that it has an impact, the injuries have an impact on the claimant and on his future earnings. Next para. Having heard the counsels on either side, there is a material non record. In this case, admittedly, the claimant had sustained 2 fractures. For that, this court is inclined to grant an amount of rupees 60,000 under the head of pain and suffering. Coming to medical expenses and loss of amenities, the amount that is and conveyance nourishment for the 10 days hospitalization, the court had rightly granted the compensation, and there are no, and even future medical expenses also. The court had rightly granted the compensation, and there are no grounds to interfere. As rightly argued by the learned counsel appearing for the claimant, for the loss of earning during the later period, no amounts are granted. Considering the salary at 21,800 for 3 months, this court is granting an amount of rupees 65,400. Then coming to the loss of future earning, this court is not able to appreciate the submission of the learned counsel for the insurance company. According to the doctor, he has sustained a disability of 16% to the whole body. He is working as a site engineer, and considering the nature of his work, it would definitely have an impact on his future earnings. In that, hence, the court had rightly granted the compensation under the said head of an amount of rupees 7,11,552, and there are no grounds to interfere with. In the light of the law laid down in Mekala also so and so towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 10,13,616, and the enhanced amount shall carry 6% interest. Accordingly, the appeal is partly allowed. The amount in deposit shall be forthwith transmitted to the trial court.
On submission. And even head of physical disabilities are not.
What is that head of physical disability? Loss of amenities, and the other head also both granted. No, there is no other head for that. Insurance company's appeal is dismissed. Yes, next. 5. Notice to both 2 and 3.
2 and 3.
Liability is on them.
Their contributory negligence is there, my lord, but it is going against him only. That's why They remained ex parte before the trial court
A memo is filed seeking dispensation of notice to R2 and R3.
at the cost of.
Memo is taken on record and the notice to the R2 and R3 is dispensed at the risk of appellant.
Apple. The case of injuries, my lord, I think my learned friend also ready. I'm ready to address the argument.
Yes.
The claimant claimed a total amount of 20 lakhs, my lord. Date of accident is 13/4/2012.
Total how much is granted?
7,39,000 with the 30% contributory calculation. So
So you are only questioning the 30% or enhancement you want?
I'm actually enhancement also I'm seeking. That's the
How
income
much is the, what are the injuries?
injuries. My type 3 compounded commuted fracture of right tibia and fibula and other injuries.
1 or 2 fractures?
2 fractures.
We'll grant 60,000. Yes, next. Loss of amenities. How much is the disability?
He was
Percentage.
percentage of disability, my lord, permanent disability 66% to the right lower limb and 29.4% to the whole body. Tribunal has assessed 10% disability. It has to be enhanced, my lord.
18%.
What basis?
18%, sorry, 18%.
What did the doctor say? What is the disability?
Treated doctor, my lord.
Doctor said, my lord, 66% to the right lower limb and 29.4% to the whole body. My lord, we have sustained, my lord,
Court had taken?
fibula fracture.
Court had taken?
18%.
Then that we will take, 28%.
18% has already considered. 18% is already considered.
No, you said doctor said 28%. To the whole body.
28.4%, my lord. It is a
No,
exaggerated.
1/3 of 66.
Please, my lord.
Well, how much is 1/3 of 66?
66.
He said 66%.
66%.
22.
Para number 33.
22. We'll consider 22. So if we consider 22, what is the salary?
Salary, I claimed 6,000. Lok Adalat 7,000, my lord.
But we will take 6,000.
I know just before this case.
So 6,000 into 12
Into 16.
into
16.
32 years, my lord, 16.
16 multiplied.
into 22.
20%.
Yeah, 22.
How much the court had considered?
5,000, my lord.
Two lakh 53,000.
53,004.
Yes.
Where is that future earning?
Third column. In
Third
synopsis
column.
again.
2,53,440.
And he was inpatient.
Then loss of amenities,
That's almost.
another 5,000.
Please.
Then loss of income during the laid up period.
Yes.
For how many months it is given?
Say 2 months, 61 days he was inpatient and another 6 months granted. So total 8 months. 5 into 8 means 40,000 granted, my lord.
We'll take it as it is.
Then 6,000 per month means 6,000 to be added.
48,000.
48. 48. Then nourishment attendant charges.
30,000.
30,000.
You are there for how many?
62 days. So 60,000 means
61 days.
61
4
days.
occasion, yes.
60,000 then.
My lord, 61 days, 4 occasion he has got
admitted.
For spells. So, but still,
Another 20,000 maybe.
50,000 is. Medical expenses as it is.
As it's all other things. I mean, it is 25,000.
Again, my lord, disfigurement
What is
again.
this disfigurement again?
That would not be,
There-
my lord. That has
It
to
is
be.
one extra column. We will take this out. Will not, but this is his appeal.
My lord,
My appeal, my lord. This.
nourishment, food and attendance charges, that may be retained. Then
Huh?
it will be,
No, what do you say? That's his appeal.
that, please, my lord, that's what my lord in the.
So,
Right?
disfigurement, 25,000 will continue. What to do? You not travel and again travel and
My
conveyance
lordship is
charges.
quantifying, my lord, then.
38.
So all too many. How many heads? Because this is there, we will not extend. Either now anyhow we cannot reduce in this, so we will not extend in other things. Where is that loss of income during laid up period? Let 40 continue. Nourishment attendant charges 50. That 30,000 be there. Because already on all the counts, so much of amount is granted.
No,
25,000 again,
only my
again
lord,
25,000.
25,000 only the extra
Settlement,
my lord.
another 25,000. Traveling and conveyance, another 25,000.
No, my lord, only 25,000 is extra. That's a,
Yeah,
No.
another 25,000 is there.
Disfigurement is not, that is
yeah,
one more.
that is only extra.
No, but
Traveling and
traveling and
conveyance.
conveyance, that would be when it is granting
Again 25,000, traveling and conveyance.
loss of this nourishment attendant, in that it would come.
Yeah, it is covered.
Hmm. So,
No, then my lord, so contribute.
it will be coming to 8 lakh plus another 10,000, 8 lakh 39,440. Yes, please come to the contributory negligence aspect.
Contributory with the claimant was a pillion rider in the two-wheeler, my lord. So there is no proof, there is no proper evidence regarding from the
How
respondent.
many pillion riders?
Only 3.
That's
Moreover,
sufficient.
my lord,
No, my
that
lord, I
vehicle
will
is
submit
kept
like
in
this,
the
my lord.
Gujri shop.
Huh?
Vehicle is kept in the Gujri shop. Without consent of that person, owner, he has taken that vehicle, Gujri shop, from the Gujri shop. And that vehicle is not.
But my lord,
runnable
see,
condition. That's
that
what
is,
my lord,
my lord, that is offense only under this an act. But because of the
They're
three,
not taking away the vehicle. 3 people traveling, 2
Yeah.
pillion riders traveling. You have also contributed to the accident.
no,
That's
because,
contributory negligence.
of driving, riding with the 3 persons, causal evidence is not there, my lord. Well, because of that one, car has come from front side and dashed against, it's only on the extreme right side of the
We
way.
have to presume this. We have to presume that. So into 30 by, we'll make it 20%.
No, 17% may be removed, my lord. That's a 2 persons, this one, 17 each. That's a 17% because of pillion rider. One is fastened on the owner of the, rider of the two-wheeler, not the owner also.
Who?
See, without the knowledge of the owner of the two-wheeler, he drove the vehicle. That is the evidence. Hence, fastened on the rider of the vehicle. That's 17% on the rider of the vehicle, 17% on the pillion rider of the vehicle.
Column number 13 vacancies. Synopsis of
Oh,
message.
now on you it is 17%.
17%.
We'll make it 10%.
The court has directed the rider of the motorcycle to pay 15% and owner of the motorcycle to pay 15% because
30.
that vehicle is not a runnable condition. It's kept in the Gujri shop. We have taken
No,
that.
about the pillion rider.
Pillion rider.
Please, my lord, that's what, my lord, the rider and pillion rider, both, all the 3 are friends. They are together.
Total contributory negligence fixed how much on all of them?
30%.
30%.
30%. That means 10.
No, no,
Not to
50.
be pillion rider. That negligence fixed against the rider of the motorcycle 15% who has taken the vehicle from the Gujri shop and 15% on the owner of the vehicle.
But then why is he saying?
Pillion rider. Owner liability.
No, let's see. Come to that.
Please, madam. Again, my lord, against.
No, my lord. Page number 38, last 4 lines. My lord. On going through the above judgment, the above mentioned observation is aptly applicable to the case on hand. Considering the above facts and for the above
Para
reason.
number?
Para number 48, page number 38, judgment page number 38, my lord.
Yes. Considering the above facts, I am of the opinion the respondent 1 and 2 are jointly and severally liable to the extent of 75%, which comes as so and so. The respondent number 3
Is not
liable
liable
to pay compensation to the
That's-
extent of,
15%.
who is respondent number 3?
The owner of the vehicle.
That's respondent number 3. Then remaining 15%?
See, 15% rider of the vehicle.
No. Then further as stated above that the driver of the alleged car has contributed and the petitioner.
Yes.
Both the pillion rider and rider 15%. This is 7.5, 7.5. Let it be.
No, my lord.
Let it be. 7.5 is fine. So 8,39,440 into
5,87,608.
No, it appears to be 7,76,000. Look at it.
30% I have. What I had to pay, I am saying. Remaining 15% and 15%.
No, no, this is 7,76,482 would be payable to him.
Please.
In that, you are supposed to pay
So, my lord.
70%.
8,39,000.
6% is liable to pay by owner motorcycle.
That's what 70% is on you.
Please.
15%
Out
on
of
the
that,
owner of the
70%
vehicle.
is liable.
No, 15% on the owner of the vehicle. Correct?
Please, my lord, 15% is
So
owner of the
70
vehicle.
out of 7,76,482, 70% will be your contribution.
Please.
What is that?
No, total 8,39,440.
Correct. 8,39,440. Your contribution is 7.5.
7.5.
Your contribution 7.5, 62,590.
I thought 7.5 each. So I thought 15%.
No, that's what 7. Yours is 7.5 as far as you are concerned. Is it correct? The calculation. So it comes to 62,958.
22.5. I have to
62,958. If it is deducted, it comes to 7,76,482. In that, 70% you will pay. 15% he has to pay. So your
No, my lord. 8,39,440 into 22.5% total. Because 30% you are deducting, out of which 7.5 is.
ಅಷ್ಟೇ ಬರುತ್ತೆ 62,000 ಹೋಗುತ್ತೆ ಅಷ್ಟೇ
into your contribution is 5,43,537 you have to pay.
Please.
Insurance company. Then owner remaining.
15%.
Not remaining.
15% and 7.5% from rider of the motorcycle.
One or only 15%.
So that also we have to quantify here.
Please, my lord.
It has to be quantified. 5,43,000.
The same ratio, my lordship would have said that.
Then 62,958 by.
My lord, out of the compensation 8,39,440, our liability would be 70%. Rest of the negligence aspect is confirmed. Like this, my lordship may pass.
No, but if you make it clear.
22.5 total. Nimi 7.5 increase.
La, the output. The same as it is. As it is.
No,
as
no.
If it is, my lord.
No, we have to quantify the.
As it is, if my lordship, MSCT has fixed 7.5 against that
15%.
2%. 15% against the owner of the motorcycle. that same
Then
30% has been confirmed.
his entitlement would be how much?
Yes, my lord, 7.5% will go, my lord. Out of that, my lordship, the MSCT passed an order saying that 15% to the injured and rider of the motorcycle. Half of the amount, half of the share would be rider, and 7.5% will go, my lord, to the injured person regarding negligence. Just of that 15% is payable by owner of the vehicle.
Hmm.
In terms of MSCT apportionment, my lordship may pass.
No, yours is 77.5%.
No, 7%, 70%.
How can it be 77.5?
See, 5% your lordship, out of 30, only 22.5% now existing, because 7.5
That's
reduced.
what I'm saying.
Yeah.
That's what I'm saying.
The 7.5% against to the injured.
Yeah, injured only. So out of 15, 7.5 added to the insurer. And 15% remained because of this one. So for him, 77.5%, 7.5% the
You
claimant.
calculate and tell the court how it is.
Pardon?
You calculate and tell the court. Anyhow, is entitled for 7,76,482. Now you are paying 5,43,537. That is 70% of your liability.
Please.
Still another how much? 15?
15% by the owner of the vehicle.
How much is that 15%? So in this 8 lakh
1,25,916.
39,440. 1,25,916. It comes to 6,69,453. And then still
Another 15% is there. Another
15, I'm saying that's what another 15% whom?
owner's liability. Owner's liability 15%. Remaining 50% is by the rider of the motorcycle, and that is shared by the injured also. That 15%, remaining 15%.
It's only 7.5. Remaining there is 7.5.
7.5 is added into plus 70%. 77.5 insurer, 7.5 claimant, and remaining 15% to the rider of the bike, my lord. That is the calculation.
Owner ಮೇಲೆ 15%, same rider ಮೇಲೆ 7%. How negligence 7%? So that has to be
injured contribution. That's what my lord has
What is
submitted.
that?
Injured contribution is
He has
7.5.
contributed 7.5%.
That will go.
That has to
That
be
will go.
deducted.
That is already gone.
So 22.5% against to the rider and the owner of the vehicle.
15% is already on the owner of the vehicle.
No,
Don't confuse the
that's
issue.
what. No.
I
It is
submit.
not a confusion, Milad. That's what they are.
See, my lord, owner's liability. No, what is telling wrong? Why I am submitting like this?
Ultimately, you are entitled for 7,76,482. Who will pay that? That we are looking at it.
Yeah, 77.5% insurer has to pay.
Why 77 insurer?
See, 7.5 the 15%
Court said their liability is fixed at 70%.
No, my submission, your lordship, remove the 7.5 fixed on the.
He is
There
arguing
are,
that our contribution has to be removed and insurance the compensation.
my lord, I submit, may I make a submission? My lord, this is 15% fixed on the rider of the vehicle, 15% fixed on the claimant, and remaining 70% fixed on the insurer. So now 15% is reduced into 7.5.
No, it is not reduced. You said there are 2 pillion riders.
No, the act, that is not fixed by the trial court.
No. Court said rider and the pillion rider, for both of them, the court had fixed 15%.
Each.
So as per you or your concern, I took it as 7.5.
No, remaining 7.5.
On the it will be on the rider.
Rider already fixed 15%. Just.
No, it's on the owner of the vehicle.
No, owner of the vehicle
Respondent is 15%.
No, owner of the vehicle exonerated because of he has not authorized it. That is the
Respondent number 1, look at it.
Respondent number
No, please read 47.
47
One.
page.
Further,
Para
as
47.
stated above, please read.
Para 47.
Respondent number 3 is the owner of the vehicle, my lord.
Read 47.
Yeah. Further, as stated above, that the driver of
Slowly,
the
slowly.
sorry. Further, as stated above, that the driver of the alleged car has contributed the negligence to the extent of 70% for occurrence of the act.
So, this insurer,
Yeah.
they have insured that car.
Yeah.
So, their liability is 70%.
Next, my lord.
Insurance company.
Ah.
No, first let us
Yeah.
clarify this.
Yeah.
Then next.
Yeah.
Ah.
Accident, and the rider of the motorcycle and the petitioner have
Petitioner is a pillion rider.
yeah,
Ah.
rider of the motorcycle and rider of the motorcycle and petitioner have contributed the negligence to the extent of 15%.
That's why I said
each.
7.5 to you.
Yeah, remains the
7.5 on the rider of the vehicle.
added to the
He was also granted compensation.
Rider of the motor.
Ah.
No, my lord, he has not claimed, I think.
He was not granted.
not there.
He was not claimed. The rider of the motorcycle has not filed any claim petition. The pillion rider who has prepared a claim petition for the MSC.
So if your lordship reducing 15% to 7.5, 7.5% to be added to the insurer.
My learned friend grievance is the 7.5% apportion against the injured may be removed.
No, if
We
the
are saying
court
that-
says, if the court says he has contributed and court fixes it, then he has to pay
That 7.5% will be payable rider only. my lord.
by the rider only.
Rider only.
The rider will pay to you. Why would the insurance company pay?
I am no way
No,
concerned with that
then
rider.
your lordship has to say 22.5 has to be paid by the rider.
No, no.
Total, my lord, 30%. Because liability not faced on the
Respondent number 3 is who?
owner of the vehicle is exonerated from the liability.
It says further the respondent number 3 is liable to pay compensation to
No,
the
my
extent
lord.
of 15. Look at it, page 35. I'm reading from the order.
47.
One niche, order, one niche. See, my lord, this petition.
Show him that end of that paragraph.
Order it has wrongly mentioned as against respondent number 3 dismissed. That's what my learned friend is saying.
Hmm.
No, judgment also stated for that reason as assigned. Page number 38, your lordship, last 4 lines.
Then we have to say that this is a correct calculation. Otherwise, where from that 15%, where from will get? Who is R3? Owner
Owner
of?
of the motorcycle.
See what happened, my lord.
Why because without his knowledge they have taken away, but then why the liability on him?
The MSC
Liability
has
not
filed
faced on the owner of the vehicle, my lord.
The vehicle is kept it in the garage, in the Guzi shop. my lord. They have taken the vehicle and get it repaired.
Probably the driver for leaving the vehicle like that unattended, court has fixed a contributory negligence on him. So 15% is on him. That we will clarify. Now the owner of the vehicle is not before the court.
Owner of the vehicle is before the R3,
Yes,
but
represented.
liability not faced on him. So I filed exemption, this on dispensation.
No, they must have. If it is not fixed on him, where is the finding that he is not about the operative portion in the discussion?
No, discuss page number 38, my lord. Judgment page number 38.
Yes.
Para number 48.
Hmm.
At the para number 48. At this stage, I have gone through the citation judgments relayed upon counsel for the respondent number 3 reported in so and so, wherein the Honorable FS Court observed in paragraph 27 of the judgment as under. The law is settled that the master
So
is,
that is also fixed on the rider of the motorcycle.
yes, 15%.
Hmm.
See, my lord, once again,
No, it is like this.
there is no confusion,
That
my lord.
15, no. That 15 plus another 7.5 is also on him.
On
Rider.
On rider, 22.5 is on the rider now.
that same house, I am requesting that made it 7.5 on the insurer. That's why I said 77.5.
Now, very safely now we can
See, my
say
lord, sir.
22.5% would be on the rider of the
My
motorcycle.
humble submission is like this, my lord. the pool is
No,
suffered.
in the last paragraph, the court must have discussed about it. The respondent number 1 and 2 being the insurer and owner of the alleged car are jointly and severally liable to pay compensation 70%. However, the respondent number 1 being the insurer of the alleged car is liable to pay an amount of rupees. What is this?
Out of that 7 lakh.
With interest till the accordingly so and so. So the court do not discuss about the other liabilities.
49, there is an ambiguity. Para 49 can be. Again, the 15% you are saying that.
The petition also contributed the negligence to the extent of 15%. So it is like this: 15% on the petitioner, 15% on the rider of the vehicle. So remaining 70% on you. Ultimately, that's what.
No, not this. My humble submission 7.5, it may be
Huh?
7.5% may be added to the insurer, my lord. It's no fault of this one, because your lordship has to kindly consider what is the graveness of the injury suffered by the claimant, my lords.
So total now it is 15% on you. As far as he is concerned, we'll make it 10%. 10% on him and then 20% on the rider of the motorcycle.
Once again, same thing.
But it can't be on the insurance company.
That's what I submit that the negligence apportion will not be disturbed.
Both are coolies, my
Whatever the
lord.
amount is
My lord,
arrived.
both are coolies. I am not getting anything from that 30%. That is
8,39,440. That is the 7,76,000. There is no, as far as your this thing is concerned, there is every clarity.
Five lakh 87,608 is our life.
6,50,000 ಬರೋದಿಲ್ಲ.
ಅವರು ನಿಮ್ದನ್ನ ತೆಗೆದಾಕಿದ್ರೆ ನೀವು ಹೇಳೋದು ಕರೆಕ್ಟ್.
ಅಲ್ಲ, ನಿಮ್ಮ ಟೋಟಲ್ ಇದೆ 70% ಹಾಕಿ ಎಷ್ಟು ಬರುತ್ತೆ?
ಇದನ್ನ ಇಷ್ಟೇ ಬರೋದು.
ನೋಡಿ 39,440 into 70%.
ಅದೇ ಮಾಡಿದ್ದು ನಾನು. ಕರೆಕ್ಟ್ ಆಗಿದೆ.
50,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
So if you take 15%, he is entitled for 7,13,524 into you have to pay 4,99,000.
No, my lord, 5
No,
lakh
5
87.
lakhs. Your
5 lakh
lordship-
87,608.
No. Earlier, what we have seen is from 8,39,440, 7.5% was taken as negligence. Now it is 15%. So 15%
No,
of
you have
it.
to
Straight away, my lordship would have said.
calculate on the 8,39,000.
440.
Huh?
8,39,440, which we have arrived, my lord.
Yes,
Out
Into
of that, my lord,
70%.
Out of that, my lord,
15%.
70% is my liability. 70%. Straight away, my lordship would have said 70% is our liability.
5 lakh
Comes
80.
to rupees, my lord, 5 lakh 87,608.
5 lakh?
87,608, my lord. Rest of 30%, my
5
lord,
lakh 87,000
608.
608.
Out of that, my lord, 2 lakh 51,832 remains, my lord.
2 lakh
51,832.
is
832.
uh,
This amount, my lord, 15% is the
This is
Right.
15%
Another
liability.
15% again.
No, this is total 30%. This
30%.
2 lakh something is total 30%.
Mm.
Out of this 15.
1,25,916 would be the 15%.
Yeah.
Otherwise, my lordship would have said 2,50,832.
No, that's why what we can do is 5,87,608.
Is my
And
liability.
no, and 1,25,916, that is 15% of the other person. So it would come to
Same 125,916, 125,916. I straight away said that 2,51,832.
7,13,524. Remaining is his contributory negligence.
No, then my lordship's 15% again I had to pay. Simple thing, my lord. 8,39,440.
Hmm.
Our liability is 70%.
Hmm.
5,87,608.
Hmm.
Rest of the amount, my lord,
Hmm.
15% contributed by the injured, 15% by the rider of the motorcycle.
30%.
That's all.
No, in that's what I'm saying is 15%. What is this 15%? What is the, that we have to quantify, which
My
is
lord.
payable by the owner of the way, by the
That's what, my lord. Owner of the vehicle is liable to pay 1,25,916.
1 lakh?
25,916.
That's what I'm saying.
Remaining amount would be the injured. It will go, my lord.
I am losing 1,25,916.
It will go to?
Injured himself.
That's
That
what
has
I'm
to be
saying.
removed.
That is his contributory negligence, 15%.
15%.
Please come.
The same amount would comes 125,916.
Agreed with orders passed in MBC number 1065/2013, dated 14 September 2016. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant in the accident. The tribunal has held that the rider, the accident has happened because of the rash and negligent driving of the driver of the offending vehicle, and also there is contributory negligence on behalf of the rider, pillion rider, to an extent of 15% each, and the insurance company is liable to pay 70% of the contribution. The claimant before this court is the pillion rider. Land counsel appearing for the claimant submits that land counsel appearing for the claimant submits that they have not contributed. There is no evidence to show that because of that they have contributed to the accident, and the court ought not to have fixed the contributory negligence on the pillion rider. It would have been the mistake of the at best it would have been on the rider, but not the pillion rider. He submits that on all other counts also. The compensation that is granted by the court is not a reasonable compensation. Para number 34, page number 34, the court has granted the compensation as per the table given below. The land counsel appearing for the insurance company submits that as they have taken a vehicle which belongs to the third respondent, and they have contributed to the accident, and the court has rightly fixed a contributory negligence on the rider as well as the pillion rider. It is submitted that on all the counts, court had granted compensation which is on the higher side, and no interference is called for.
Next para, having heard the counsels on either side, peruse the material on record. First of all, coming to the contributory negligence, considering the facts and circumstances of the case, where they have taken a parked vehicle and they have driven they have taken the said vehicle without even the notice of the owner of the vehicle, and in those circumstances, fixing the contributory negligence on the driver as well as the rider as well as the pillion rider by the tribunal is a well considered one, and no interference is called for. Then coming to the compensation, court had granted, the claimant had sustained 2 fractures. Court had granted under the head of pain and suffering 55,000, and this court is granting 60,000. Loss of amenities, an amount of rupees 30,000 is granted by this court. Then coming to the loss of future earning, the case of the claimant is that he is earning 6,000. Court had taken 5,000. Considering that this accident is of the year 2000, 2012, this court is taking the income at 6,000. And the doctor has deposed that the claimant had sustained disability to the whole body at what percent?
66% to the right lower limb.
66% to the limb.
Right lower limb. 29.4% to the whole body.
29.4%
to the whole body.
Whole body. Court had taken?
Yeah, MSC has considered 18%.
18%, considering 1/3 of the disability to the limb. This court is taking 22%. The loss of income will come to 2,53,440. Coming to the loss of income during the laid up period, nourishment and attendant charges, medical expenses, disfigurement, traveling and conveyance charges, future medical expenses, court has considered and granted reasonable compensation. Hence, this court finds no reasons to interfere. In the light of the law laid down in so and so, the claimant is entitled for an amount of rupees 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 8,39,440. In that, the insurance company is liable to pay 70% of the compensation. It comes to 5,87,608. The rider of the motorcycle has contributed to the accident, that is the liability contributory negligence is at 15%. Hence, he is liable to pay an amount of rupees 1,25,916. Accordingly, the remaining 15% is the liability of the claimant. Accordingly, the petition is partly allowed. Yes.
Chair number 6.
Machu.
Guna
I appear-
Reddy.
6, I appear for the appellant, my lord.
Yes.
It is a case of injury. 742 days delay is there, my lord.
Yes. You're seeking enhancement.
Yes, my lord. I am seeking enhancement. And the
Yes.
accident is of the year 2011, my lord.
2011. Take that.
And nature of injuries are concerned, my lord. First one, fracture of shaft of humerus left.
1 minute. The compensation awarded is
3,24,000. 24,000.
Mm.
And the injuries are, my lord, first one is fracture of shaft of humerus
Disability
left.
assessed by the doctor is 35.4%.
35 told to the whole body, but tribunal has taken 10%.
12%.
But dentist also, dental doctor is also says that 12%.
There is no dispute on that.
So far as other injuries are concerned, my lord, last
No, there is no dispute on that.
No, my lord, here 2 doctors were examined. They are saying that another facial reason 12% has been assessed by some other doctor. That has to be considered.
Other doctor said?
Another doctor 12%.
12%.
Dental surgeon.
How much the court had taken?
Court has taken, my lord, 10%.
10%. 10% you lost
No.
it.
Facial disfigurement is disability on that. Only humerus fracture, my lordship has to consider the disability. Facial fracture, there is a disfiguration, my lordship would have grant compensation under date.
Not facial.
So as far as that is concerned, according to the doctor,
Last
how much is How much is the disability? What is the percentage of disability?
Percentage of disability, my lord, on the orthopedic surgeon was assessed 34.4% to the left upper limb, 12% to the whole body.
Court had taken also 12%.
10%.
No, 10%.
So if we have to take,
And
how many
another
are the injuries? Pain and
PW3, your lordship may kindly see, multiple head, that is fracture of
5
Ili's
teeth.
scalps. Ili's scalps means the loss of 5 teeth, my lord. Loss of 5 teeth and fracture of other teeth. So far as dental surgeon is concerned, there was functional disability is 12%, whole body. That is not taken into consideration.
Pain and suffering needs to be enhanced.
That's what my lord I'm
80.
saying.
He cannot chew the food, he cannot.
Suffering and loss of community may be increased.
He has
Pain
to
and suffering
undergo,
80,000.
he has to undergo for artificial denture, my lord. That has to be replaced once in 3 years. That
No,
is
we
the
are
evidence.
going step by step. We are going step by step. Pain
Yes,
and
ma'am.
suffering, now we'll grant 80,000.
Yes,
Then
ma'am.
we will come to loss of income during the laid up period. What is the income?
The tribunal has taken 7,500 per month. He is a tailor. That is established because charge sheet has been shown as a tailor.
No. According to the claimant, he is earning 7.5.
No, my lord. 400, 500 per day, but the tribunal has taken 7,500. Tribunal 7,500.
400 to 450 per month.
400 to?
450 per month.
So how much it will be? 12,000.
12,000.
Which year is the accident?
Accident occurred in the year of
2011.
10, 12, 2011.
2011 means 6,500.
500. Already 7,000.
Court had taken?
Tribunal has taken 7,500 on the ground. He is a skilled worker.
We will also take 7,500.
Yes, my lord.
So for how many months it is given? 3
6
months.
months he was hospitalized. He has undergone one surgery. Implants were inserted. So far as that is concerned, my lord, for incidental charges,
6 months.
25,000 has been awarded by the tribunal.
Just for 6 months.
We'll hear it when you are in the court. When will you come physically?
I'm sorry. Tuesday I will come, my lord. Monday.
Let's just matter in Tuesday because it's difficult.
Yes, much obliged.
Yes, Tuesday. Let's just matter on Tuesday. We'll see on that. Yes. Or else it will come on Tuesday. We'll condone the delay on condition. I number 1 of 17 is filed to condone the delay of 742 days. Same on condition. On condition. Yes. Let's just matter on Tuesday. Yes, 7.
Serial number 7, Pradeep B for appellant.
This case now challenging the liability on the ground that the insured vehicle driver who has not possessing driving license. 3-1 charge sheet has been filed by the police.
Is a third party.
Liability is fixed against the appellant insurer.
Pay and recover.
One more ground I raised, my lord, but income taken is lesser side. That's what I.
But any of their appeal is not there.
My appeal only.
No, you are saying it is taken more.
More.
No.
This is
How much is taken as?
He was aged about 43 years. The multiplier should be taken as 14 instead of 15.
But income.
So far as total compensation is concerned,
It's on the lower side.
It doesn't call for interference.
Agreed with the orders passed in MVC number 1818 of 2012, dated 2nd January 2015. The insurance companies before this court, the tribunal had fixed the liability. Where is the finding?
Internal page 12 from the bottom 10th line. But the first point being the owner of the pending vehicle was remained absent.
The expert.
Internal page 12 from the bottom 10th line.
Mm.
In the middle, but the first respondent being
No, it says the insurance company has not made efforts to prove that the driver was not having a driving license.
It's a charge sheet, but independently they have not summoned any person.
Part of the charge sheet cannot be considered.
The
charge sheet is there.
The court had fixed a liability on the insurance company holding that the insurance company has not made any efforts to prove that the driver was not having a driving license to drive the lorry as on the date of the accident. Hence, as the policy was enforced, the insurance company is liable to pay the compensation. When counsel appearing for the insurance company, appellant insurance company submits that the evidence, the charge sheet is filed by the police against the driver of the offending vehicle under section 137 read with 197 of the IMB Act, section 134(3) read with 187 IMB Act, and section 3 read with section 181 of the IMB Act, which clearly shows that the driver of the vehicle is not having a driving license as on the day. It is submitted that when the court had taken part of the police records and considered that the accident had taken place, and as far as it comes to the driving license, court has failed to consider the same, and it's not for, he submits that the same is not legal. It is submitted that when there is no driving license, the insurance company is not liable to pay the compensation. Then counsel appearing for the respondent claimant submits that the claimant is a third party to the insurance policy, and whether the claimant is having a valid driving license or not, still the insurance company is liable to pay the compensation. Next, having got the counsels on either side, there is a material on record considering it is a case of it is argued by the land counsel for the insurance company that as a driver is not having a valid driving license, he is not liable to pay the compensation. And according to it is a finding of the court that the insurance company has failed to prove the same. This court has perused the order and the FIR and the charge sheet that is registered against the driver of the vehicle, which shows that he is not having a valid driving license. In that view of the matter, it has to be presumed that the driver of the vehicle is not having a driving license. Even in that case also, insurance company is liable in the light of the law laid down in Swaransingh's case. However, the insurance company shall pay the compensation and require the same from the owner of the vehicle. Accordingly, the appeal is partly allowed. The amount in deposit shall be forthwith transmitted to the trial court. Yes. Next,
Number 8. Pradeep B. Appellant.
This case also challenging the liability on the ground that
Where is the counsel? Nobody is appearing.
Surendra Kumar.
He is appearing for the claimants.
Surendra Kumar.
Heard the counsel for the appellant. No representation for the respondent claimant. List this matter on Wednesday. Yes, next. Parted.
Yes, my lord.
Serial number 9.
The senior also requested me, my lord, some other day.
Which one? 9.
No, 9, my lord. I am for R1.
Day.
Yes. List this matter on Wednesday. Yes.
Serial number 10. Serial number 10. P for appellant. SV plus.
I appear for
You appear for whom?
appellant
Yes.
on behalf of Pradeep.
Why Pradeep is not there?
Okay.
Yes.
Yes, read some other papers. That's the reason I have read it.
Yes. Who appears? You appear for the respondent.
Insurance company appeal challenging the negligence.
Challenging the negligence.
Negligence, only negligence.
That you say that there is no negligence on the part of the offending vehicle.
No, he is also contributed for the accident.
That's your case. Oh. Come, let's straight away read that paragraph.
Please. The issue number 1. In that, my lord, para number 19 onwards is the 22 may be very relevant for them. In the definite defense of the insurance company that there is a violation of the variation in the sketch exhibit P4 and also exhibit P7. According to the defense, exhibit P4 is the manipulated by the petitioner colluding with the police. In this context, they have cross-examined the petition witness and also confronted to the exhibit sketch of exhibit to RW1 driver come the owner of the Swaraj Mazda. When he admit the same, it is marked as exhibit 7. The insurance company summoned the IO, examined the R1 so evidence deposed that after the accident, he has visited the spot and drawn the hazard. In view of the summons to the witness, he has produced the case file, which was marked as Exhibit 7. Panchanama available on record, which marks as Exhibit 7A. Sketch is marked as a 7B. In his evidence, he said that as per the sketch, a motorcycle was proceeding from Masur side to right side of the road. The signature marked as Exhibit RB. In the evidence also stated that the case does not consist of Exhibit P5 and P7. In his cross-examination, he said that his signature is also found in Exhibit P4 and P5, which has been produced by the petitioner in this case. He has stated that he cannot say who has written the Exhibit P4 and 5. Further, he has stated that Exhibit P4 is an unwritten writing. Exhibit R7A written by his colleague. Exhibit P7, the 5 is not in his handwriting, but he has attested his signature. In Exhibit R7B, only his signature is found, and other wordings are not in his language wording. It is also stated that panchas of Exhibit P4 and 7A signed by the same witnesses were. When the court summons the question, the witness why P4 and P7 R7 Mahazar came to existence in the single case. For that, this witness stated that he is not in a position to say, but so and so. This is the observation. Your Lordship, kindly see the sketch, both the sketch and the evidence, where he says that my lord, Exhibit P5. Exhibit P R7, my lord, the entire negligence on the part of the rider of the motorcycle, if that is taken into consideration. May I read full?
I'm reading para 26, middle of para 26, please read.
Please.
But it is very much clear.
Para 26, my lord.
Middle of para 26.
Please, do signature pancha to witness up number 2 in respect. Bracket.
After Exhibit P4.
Please. But Exhibit P4, the Mahazar does not reflect the same. So it is very much clear that Exhibit P4 is entirely different, and original is also found the place in any of the police record. Though police have drawn two Mahazar, two sketch in the spot, they have not disclosed why they have drawn two Mahazar and two sketch at this spot at same time for the same accident. PW3 in his evidence stated that one police have drawn the two Mahazar, then they have not written in detail. Hence, once again they have drawn the Mahazar and sketch. Though RW3 is examined by the insurance company, he has also not given any explanation to two Mahazar and two sketch came into existence. But the contents of two Mahazar are one and the same. Why the sketch is different? On going through the contents of Mahazar in detail, it is reflected that the respondent one has driven the vehicle rash and negligent manner and caused the accident. Your Lordship, kindly see the sketch which was marked by the.
No, what they say is the content of both the sketches is one and the same. In one sketch, it is shown that the person is on the wrong side.
Please.
The claimant. In the other sketch, he is shown as being on the right side. So when there are two, why should we not look into this? Why should look at what you are showing?
What my respect submission, not considering these and the evidence
No,
of
content is one and the same. Content shows accident has happened because of the negligent driving of the offending vehicle.
Eyewitness of the accident is the driver of the insured vehicle has been examined. Says that the contrary to that, the sketch.
You would say that he has not committed any wrong. It is because of the claimant.
Correct. Considering that, my lord,
charge sheet is filed.
Charge sheet is filed. There is no doubt in that aspect, my
lord. Examined IO in his cross examination, he admitted exhibit D7 and 7A is not mine. It is written by somebody. But exhibit P4 and 5 written by himself. He admitted. Therefore, my lord, he admitted in the cross examination saying that the negligence is on the part of the driver of the canter vehicle, offending vehicle. Therefore, we have to file charge sheet against him. Your Lordship, kindly permit me to read.
The rider of the motorcycle came on the extreme right
Correct.
side
That
of the
is
road
as
and
per
dashed
one
it.
sketch.
Please,
As per one sketch.
please.
Other sketch shows
Please.
something else. That
It is in the middle of the road.
Ah.
It is in the middle. That's what my respect. I mean, Lordship has put the question how you are challenging negligence. What I am saying that, my lord, I am not saying that my driver is not negligent. All of the document disclosed, my lord, he is also contributed. Contributory negligence has to be taken into consideration.
That is as per one sketch, not both the sketches.
Both the
My lord,
sketch, my lord.
the
Your
second
Lordship
sketch,
kindly
as
see
per
both
second
sketch.
sketch, my lord,
Your Lordship can
Both the
kindly see both sketch.
Second sketch exhibit, sir.
7A, D7A,
R7.
D
R first. R
D7B, D7B, rough sketch. This is the second sketch. My lord, UO, my lord, in his cross examination specifically admitted that the exhibit P4 and 5 written by him only at his spot. Later on, my lord, the second sketch and marge are written by somebody else, not by him. That statement, my lord, the admission, my lord, the forthcoming in the judgment also. That's why, my lord, the liability fastening on the insurance company.
R5, madam. R5.
My lord, sketch also, my lord, earlier sketch, my lord, the motorcycle is on the left side. The second sketch prepared later on, that is in the right side.
That's what.
Your Lordship, there is a photo
There are
where
two
the motorbike lying on the road.
That is
Your
the
Lordship, kindly come to the photograph.
exhibit R5 and R7.
What is the vehicle the claimant
R5.
is?
R5.
What is the vehicle involved?
Oh, P5 also.
One is canter, another one, my vehicle is motorbike. My lord, I
P5,
have
I think
also
it's-
filed
madam,
appeal
P5
for enhancement,
Same, ella onde.
cross appeal for
Where
enhancement.
is that?
My lord, cross appeal number 76,
point.
They have also prepared class appeal, my lord, for seeking enhancement.
enhancement.
10.1.
R P5 ಕೊಡಿ madam. ತೊಂದ್ರೆ ಇಲ್ಲ P5 ನು ಕೊಡಿ ತೊಂದ್ರೆ. ಕೊಡಿ ಅದನ್ನ ತೊಂದ್ರೆ. My lord, the insured lorry was coming from Sikaripura to Masururu.
I am
Right.
looking at exhibit. What is this exhibit?
P5.
P5.
Please, man.
It's by them.
Before that, my lord, I will how the vehicle was moving. I will explain. From Sikaripura to Masurur, the insured vehicle was coming. Opposite direction, the rider of the motorcycle was coming. Now, your lordship, kindly see at the extreme left side of the Sikaripura, from the Sikaripura, the very accident was occurred. This document was marked by the petitioner, relying on the. After that, my lord, these document, we have summoned the document to confirm this. At that point of time, my lord, these documents were not available in the document, and the entire different document were placed before the court.
So where is the vehicle? From exhibit P5.
Place of accident, it is on the extreme left of Sikaripura. Your lordship, kindly. This is Sikaripura. From here, he proceeding to Masururu. The place of accident is here. After that, my lord, the vehicle was shifted to here.
Left side, not right.
My lord, this is in Canada. My lord, this is Sikaripura. My insured vehicle was proceeding this on the left side of the road.
What is that road from, it is showing like cross of it.
It is not in cross.
My lord, after my lord collusion, my lord,
Sikaripura. This is the place of
No,
accident.
that 2 lines is a road, right?
This is not the Kacha. This is service road. The
What is
footpath.
it? You read this? Hmm. Where is going from where to where?
This is only footpath, my lord. Side of the road. Mud portion of the road.
I'm not talking about, I'm talking about this side. These 2 lines. Where is the main road as per that?
This is main road, my lord. There is a Kacha road up on the both the
In
side.
between is
between
the.
is the road.
Uh,
It is only this is the two-way road, my lord. One vehicle, my vehicle is coming from Sikaripura to Masroor.
That road to this.
Please. Opposite direction, the motorcycle was coming. Well, now your lordship see, from the Sikaripura, I was proceeding on the left side of the road. The accident, edge of the mud road, the very accident was taken place. That means he
So a person who is coming from that side should be
came
in
on the extreme right side of the road and dashed against the motorcycle.
No, he is coming from that side. So wait,
He'll
so that.
Your lordship kindly see for
No,
that
no,
also.
I'll tell you. You're
Pancha-
coming from,
May kindly be seen before.
no. You're coming from this side.
Please, from Sikaripura to Masroor.
Here to here he is going.
Now your lordship kindly see, the very accident was on the left side of the mud road of the
Where is the accident? Here.
edge of the Kacha road. The very accident was occurred. That means the rider had a 30. This is 30
That
feet road.
means he is, if you're coming from that side, you should be on this side of the road.
But I am coming from Sikaripura to.
Correct. Then you will not be this side. You will not be on the left side. You will be this side.
No, this is Sikaripura, madam. This is Masroor. The arrow mark like this.
No.
Arrow mark, your lordship kindly see the arrow mark. This is arrow mark, Sikaripura, towards Sikaripura. Here. From this is towards Masroor. That means, my lord, I am on the left side of the road towards Masroor.
So he'll be going
How I
this
can
side.
go to the right side, madam?
You have got that.
No, my lord. This is
But that is what is shown. This is the place, no, where the accident has happened.
my lord, from Sikaripura, this is given arrow mark towards Sikaripura. I am coming from Sikaripura to Masroor. That is opposite direction. The arrow mark which was given to that arrow mark, I am coming opposite. Because
It's not a one way.
it is not one way.
One way. So the vehicle, it is, forget about the name of the places. You're coming from this side to this side. You will be in which direction?
Left side of the direction.
So you
Road.
will be this direction.
Please.
This person is going from here to this side.
Correct.
He
And
will
the
be on
other
this
portion.
left.
Please.
Accident happened on the extreme left side of the road.
Left side of my my vehicle which was proceeding.
It would be right side of your vehicle.
No, it is on the left side of my vehicle, Mila.
Yes, Mulad, there are two sketch
I
and
am
two
looking at
major.
exhibit
That's why.
C5.
That's why this is the second sketch.
Ah.
This is the second sketch. That's why.
Second sketch, which is the second sketch, I don't know.
We'll continue. This is matter Monday?
Any day, Mila.
Monday.
Oh, not Monday, Milad. Tuesday or Wednesday.
Thursday.
Any day, Mila.
Please, Milad. Oblige.
Really out.
So, Simarani judgment. Keep it with you.
Monday.
Lordship, remaining matters.
Remaining matters now tag on to the list. To the everyday final hearing list. Oh, number 3. Yes.
Monday.
It will come on Monday. It'll be tagged on, and because they're old matters, they'll be coming on the top.
Please,
And please give the list of anybody who's having 12, 13 matters.
please.
12, 13.
ಹೇಳಿದ್ದೀನಿ.
But they have given on 16 matters.
12-13 ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಕೊಡ್ಬೇಕಂತ ಕೊಡೋಣ ಇಷ್ಟು.
Let them pick up and give priority to 12, 13, 14.
ಅಲ್ಲೋ ಆಮೇಲೆ ಮಾಡೋಣ. ನೋಡು ಎಕ್ಸಿಬಿಟ್ P5 ಅಲ್ವೇನಪ್ಪ? R5
ಹೌದಲ್ಲ ಸರ್ R5 ಅದನ್ನ ಬರೋಣ.
ನೀವು ತೋರಿಸ್ತಾ ಇದ್ದಿದ್ದು
P7
ಹೆಂಗೆ 2 ಸ್ವಿಚ್ ಅಂತ ಹೇಳ್ತೀಯಾ? Come and tell me. ಇಲ್ಲಿ ಬರ್ತಿದಾರಾ? ಏನ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ರೆ?
ಇವನೇ ಕ್ಲಾಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಇವನೇ ಕ್ಲಾಸ್ ಮಾಡಿರೋದು.
ಆಯ್ತು ಬಾ.
ಇದು ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೇನು ಬರಕ್ಕಿಲ್ಲ.
ಹೇಳಿದೀರಾ?
ಅಲ್ಲ
ಬೇರೆ ಕಳ್ಸೋರ?
ಅಲ್ಲ 17, 12, 13 ಎಲ್ಲ ಲಿಸ್ಟಲ್ಲಿ ಇದೆ ಅದು. ಮೊನ್ನೆ ನೋಡಿದೆ ನಾನು.
ಇವೆಲ್ಲ ಸೋಮವಾರ ರಿಪೀಟ್ ಆಗುತ್ತಾ ರೀತಿ ಆಗ್ತಿರೋ?
ಅದೆಲ್ಲ ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಅಂದ್ರೆ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೆ. ಇದನ್ನೆಲ್ಲ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಹಾಕ್ತೀನಿ. ಡೇಟ್ ಕೂಡ ನಿಮಗೆ MFA ಪೆಂಡಿಂಗಿಗೆ ನಾವು ಲಿಸ್ಟ್ ಕಳಿಸಿದ್ದೀರಲ್ಲ, ಟೋಟಲ್ 25. ಟೋಟಲ್ 25. ನಮ್ದು ಲಿಸ್ಟ್ ಕಳಿಸಿದೀವಿ. ಓಲ್ಡೆಸ್ಟ್ ಮ್ಯಾಟರ್ನ ಕಳಿಸಿ ಅಂದ್ರೆ ನೀವು ಕಳಿಸ್ತಾ ಇಲ್ವಂತಲ್ಲ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ಗೆ. ಎಲ್ಲ 16, 17 ಕಳಿಸ್ತಾ ಇದ್ದೀರಾ. ವಾಟ್ ಅಬೌಟ್ 13, 12, 11? ಅಲ್ಲಪ್ಪ ಮೇಡಮ್ ಇವಾಗ ಕೇಳಿದ್ದಾರೆ, ನೀವು ಇದೇ ತರ ಕಳ್ಸಿದ್ರೆ ನೀವೇ ಬಂದು ನಿಂತ್ಕೋಬೇಕು. ಅದೇನೆ ಓಲ್ಡೆಸ್ಟ್ ಇಂದ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿರೋದು ಮೇಡಮ್. ಟೋಟಲ್ 25ಗೆ ನೀವು 16, 17, 18 ಕಳ್ಸಿದ್ರೆ ನಾವೇನ್ ಮಾಡೋಣ? ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಫಾಲೋ ಮಾಡ್ತಿಲ್ಲ ಇವ್ರೆ. ನೀವು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಫಾಲೋ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಯಾರನ್ನ ಕರಿಬೇಡಿ, ನೀವು ಸೆಕ್ಷನ್ ಆಫೀಸರ್ಗೆ ಹೇಳಿ. ಅಂತಲ್ಲ 50 ಜನ ಈಗ 50 ಜನ ಪಾಠ ಹೇಳಕ್ಕಾಗಲ್ಲ ನಾನು. ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡೋಣಪ್ಪ. ಇದು ಎಂಡ್ ಮೀಟಿಂಗ್ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಬನ್ನಿ ಒಂಚೂರು.
ಅವೆಲ್ಲ ಮಂಡೆ ಕೊಟ್ಬಿಡಲ್ಲ ಡೇಟು?
ಉಳಿದಿದ್ದೆಲ್ಲ ಮಂಡ್ಯಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಬಿಡು. ಎಲ್ಲಪ್ಪ 3 ಡಾಟ್. ಹಾಂ